All right, we're back once again. Let this run for just a minute. There should be somebody there shortly. So I'm gonna, again, shut off the chat. Thank you for saying good morning. And we're gonna stop it again and then pick it up again at 10:30 with our criminal sentences. See if we have anybody.
Inside this quiet courtroom, tension sits just beneath the surface. The judge is juggling an overloaded morning docket, calibrating patience against punctuality, and scanning for a defendant who could turn this routine call into a problem. Moments like these set the tone. Either the process flows or it stalls and hardens into consequence. What looks procedural is actually precarious. One absence or late appearance can trigger a bench warrant, a chain reaction that escalates instantly from paperwork to custody. Watch how the court balances efficiency with fairness, and how a single person's readiness, or lack of it, reshapes everyone's day. Would you risk this judge's schedule with even a minute of avoidable delay?
Don't. Well, nothing jumped out at me, Matt. This is a phone number. This would be our defendant.
When a judge is verifying numbers on the record, it's not casual. It's a signal that attendance is uncertain and consequences are nearby. Courts run on reliability. Notice goes out, parties appear, orders follow. Miss a hearing, and the system asserts itself through a bench warrant, empowering law enforcement to bring you back the hard way. It's not punitive for sport, it's how the court protects its own authority and the rights of the opposing party. In a live calendar like this, every gap risks snowballing delays. The judge's clipped phrasing here tells you everything. He's searching for the defendant and for assurance that due process can proceed. If one missed ring could spiral into arrest, how car?
Good morning. Am I speaking with Elizabeth Robinson?
Yes, you are.
All right, thank you. You're here. The other party is not here on behalf of the bank. So let me put you in the waiting room for a moment.
Okay.
Don't go away, all right?
Contact made. Tone matters now. Robinson's answers are brief, respectful, and careful. Exactly what judges listen for when gauging credibility and cooperation. Even in a civil case, presence and demeanour can be decisive. The court isn't just processing numbers, it's reading intent. A defendant who shows up, listens, and responds directly gives the judge room to work toward a fair process rather than a coercive one. Notice how the judge acknowledges her presence, yet immediately secures the proceeding. He parks her in the virtual waiting room to keep the calendar moving. That's discipline and efficiency, signals that this courtroom rewards order. In her place, would you try to explain everything now, or keep it concise to earn judicial
all
trust
right?
first?
All right, here's the plaintiff.
Good morning again.
Good morning. Had so much fun the last time, we thought we'd do it all over again.
Right.
All right. Our last general civil pretrial of the morning is entitled Synchrony Bank versus Elizabeth Robinson. Elizabeth Robinson is here by telephone, which isn't ideal, but it's better than not being here. Attorney Veronica Lakariki is here. I think I'm closer to how you say it than what I was saying on behalf of
No,
the plaintiff.
that's right. That's right, Your Honor.
All right. The claim here is for $6,050.59. The defendant, once served with the lawsuit, filed a letter sideways indicating they had offered a settlement as part of a credit care reconciliation company. And I wasn't clear. They were going to take a lump sum and then the deal failed. And she's asking for some sort of repayment agreement. Is that correct, Ms. Robinson?
Yes, that is correct.
Are you still working with this credit care company?
I have not had any contact with them since the trial started, no.
All right.
And Your Honor,
Here's the legal core. A $6,509 claim, a failed third-party settlement pitch, and a plaintiff ready to talk real numbers. The attorney's skepticism about debt settlement outfits is common. Many charge upfront fees, stall communications, and leave defendants worse off when litigation starts. The judge answers with nuance. He's seen both outcomes, which is exactly what you want from the bench. Skepticism without prejudice. The question now is leverage. Robinson has shown up and is responsive. The bank has given counsel authority to negotiate. That combination is fertile ground for compromise if the terms are concrete, enforceable, and time-bound. If you were in debt and on the record, would you gamble on a fixer company again, or deal directly with the party that can actually close your case?
company, and I always tell people I think that settlement companies are a scam personally, but they never responded to us. They never even indicated that they were, representing her. In fact, we were in line to file a default because aside from the letter, there was no answer. However, I'm glad that we're here today because I would certainly like to speak with her on a settlement. I do have good settlement authority from my client. So that's what I'm hopeful for.
All right. I'm going to put you both in a breakout room. I certainly have seen a lot of people in worse shape with debt consolidation companies than before they started. But I'm reluctant to just paint them all with the same brush that they're all scams, because I've seen some people benefit from them, but I've seen a lot of people get victimized as well. Miss Robinson, I'm gonna put you in what's called a breakout room where you can speak privately with the attorney for the bank and discuss a potential settlement. So let me put you in there with Ms. Bakariki and you can discuss the matter. I'll be right here thinking deep thoughts and waiting for you guys to come
This
back.
is the turning point. A virtual breakout room replaces the courthouse hallway, but the dynamics are the same. Pressure, pragmatism, and proof. Robinson needs specifics. Total, monthly amount, start date, and what happens on default. The bank needs enforceability, consent judgment, clear mailing address, and a timeline to file. Good settlements trade uncertainty for structure, and judges reward parties who memorialize terms cleanly. If Robinson keeps her answers steady and verifies logistics on the spot, she can cut principal, freeze interest, and buy predictability. If not, she risks a default judgment that follows her for years. In private negotiation with the clock running, would you push for a deeper discount or lock a safer plan you can actually keep?
We are addressing file number 25379 GC, Synchrony Bank versus Elizabeth Robinson. I put the attorney Lakariki and the defendant in a breakout room to discuss a potential settlement. And Matt, I looked at the in custody roster again. And I'm not sure which case you were referring to. There's some bad stuff in there. Again, world's most boringest live stream to watch me sit here and watch the screen. But I will clear some cases out of here. as I indicated, we have 7 sentences. Some need translators. We start at 10:30.
All right, Your Honor, we're all set.
All right, let me bring her back. Take me a minute to close the breakout room. All right, Miss Robinson, can you hear me?
Yes, I can.
All right, the parties were placed in a breakout room. Attorney Lakariki is ready to address that. Were you able to accomplish anything?
Yes, we came to a settlement and I am ready to present the terms.
All right, go ahead.
So it's going to be a total of $2,800. That's $2,800. No additional penalties, costs, interests. And that's going to be paid in 24 months, with the first payment being on November 14th, and then the 14th of every month after that until paid in full. I believe it's going to be $117 a month. And we're going to send the consent judgment over to her address, which I have confirmed with her. And hopefully we can get this all wrapped up.
All right, it sounds like a pretty generous settlement. The debt is being compromised from over $6,000 down to $2,800. Payable at $117 per month over 24 months, beginning November 14th and the
This is
14th
what a
of each
clean,
month.
enforceable deal sounds like. Principal slashed to $2,800, interest and fees waived, a 24-month runway, and a specific due date. $117 due on the 14th each month. The consent judgment is the guardrail. If payments are missed, the plaintiff can file swiftly. For the court, clarity equals fairness. For Robinson, predictability beats fear. She knows the amount, the cadence, the start date, and the mailing steps. The judge checks voluntariness to protect the record, and her "not at all" locks the agreement in. If you'd just cut your debt by more than half, would you celebrate the discount or worry about the discipline it now demands every
14th
month?
of each month. Miss Robinson, did you agree to those terms?
Yes, I did, Your Honor.
Was there any undue pressure or coercion placed on you to come to that agreement?
Not at all.
All right. They're gonna send a copy of that to you, and then you need to sign it and send it to me. I will tickle this for 24 months or 14 days to await the consent judgment. All right, is there anything further we need to place on the record?
Just to clarify, we'll be mailing it to her, and then once she signs it, she can mail it back to us, and we will file it.
All right, very good. Hopefully that can be done within 14 days. Ms. Robinson, do you have any questions?
I do not.
All right, Ms. Lakariki, you're in your mobile headquarters. You can, I guess, get back to your next stop.
Gavel down. Lesson clear. A morning that threatened warrants ends in a negotiated path forward. Smaller principal, zero added interest, and a timetable the defendant can actually meet. The court guarded its calendar and its standards without crushing the person in front of it. That's the real measure of justice here. Firm procedure paired with practical mercy. Robinson still carries responsibility, but not an impossible burden. For viewers, remember, show up, stay calm, get specific, and lock terms that you can keep. Was justice served, or was this disciplined mercy at work? If this breakdown helped you see how outcomes are shaped in the quiet moments, like, comment, and subscribe for more precise courtroom analyses every week.
All right, that completes the record on this matter. I'm glad we were able to resolve it. It seems like a pretty good settlement for the defendant and closes the case.
Thank
All
you
right,
so much.
thank you.
Have a good
Okay,
day.
you're good to go. Thank you.
Thank you.
All right, we're going to stop the record again. I'm going to go gather the criminal files. Be ready to hit the ground running at 10:30. As said.